Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. This week, we're talking about trademarks and maximizing trademark protection, the first use, the research strategies, start strong and finish strong. So today, this first of the 4 episodes for this week, we're going to talk about terrible versus terrific trademarks. So a quick story. A couple months ago, I was at a networking event with people from all over the country, and I met an attorney, and I wanted to follow up with that attorney for networking purposes. I had jotted down his name and his area of law he practiced. I didn't remember exactly where he was in the country, and I didn't get a card or contact information. So when I went to look for him on the internet, unfortunately, he had a very common last name, and there were dozens of different attorneys with the same name, and it was very difficult to find him in this way. So in his case, his name made a terrible trademark because it was not easy to distinguish his name from other attorneys and quickly and easily find him. This is what a trademark needs to do. It needs to distinguish you from others, make it easy for customers, consumers to find you again and again. Now, why is this important? Well, we're going to talk, of course, it's important because you want to establish a strong brand, but another reason we're going to talk about what makes a strong trademark or a weak trademark is because the courts and the trademark office, whenever they have a contest between 2 different trademarks or 2 different people that are using a trademark, one of the primary questions they ask is, how strong is this trademark? Now, if you're picking a trademark, you might want to consider picking a strong trademark that's considered strong by the courts right off the bat. If you've already got a trademark, you might want to know where it falls so that if you do need to go forward and enforce your trademark, you'll understand a little better of how broadly you can enforce that, and you hopefully won't pick a fight you're not going to win. That can be very costly. So there are 4 trademark strength categories. They quickly are generic, descriptive, suggestive. Those are the first 3. And then the 4th one includes fanciful and arbitrary. So a generic trademark is just like it sounds. It describes what it is that you're selling. Or generic, that's descriptive. Generic is the noun. It's what people say it is. So for example, if you have a moving company and you only have the word moving as your brand, you're not going to be able to distinguish your moving brand from other movers because you don't have anything that other than a generic term. So generic terms cannot be protected as a trademark. And as a cautionary tale, there are brands that have become generic because that's what the public starts calling it, as the noun of what it is. So a quick example of that is the escalator. The company that invented the escalator, they got a patent. So they had 10 or 15 years of exclusive rights. They were the only ones selling the escalator, but they were calling it an escalator. They weren't calling it an escalator brand moving staircase. So the word escalator got associated with what it is, not who provides it. And because it was a new product and it got associated with what it is, when they went to enforce that trademark, the people that were being sued convinced the courts that this was not a trademark, it was a generic term. And so that even though they had registered it as a trademark, it became a generic term, and they had to use other branding terms to distinguish their escalator from other escalators. So that's generic trademarks. They can start out generic or they can become generic. Descriptive. There are really two categories under descriptive. There's merely descriptive and descriptive that has acquired secondary meaning. When something is merely descriptive, the Trademark Office will reject it. So an example might be if you were to apply for the term reliable movers. It merely describes and says that you are reliable. That's actually something that people would be shopping for, is a reliable mover. And so people would not expect that to be a brand and a source designation of who's offering it. They would expect more of it to be what you're offering. Describing what you're offering is merely descriptive. Now, over time, with proper advertising and continuous use, and if you're the only one using it as a brand, it can acquire a brand meaning, and that's the secondary meaning. And so what can happen is we can apply for a trademark, and if they reject it as merely descriptive, we can actually list it on what's called the supplemental register. That's a register where you don't get the exclusive rights, but you can still actually use that circle R as a registered trademark. Now, you don't have the exclusive rights, but if you build your evidence and then after 5 years present that evidence to the trademark, then if they accept that you have bridged that gap and now people recognize it as a brand, then they will register it on the principal register where you're considered to have exclusive rights. Even though it's considered a descriptive term, it has obtained that secondary meaning. So that's the second. So descriptive is the lowest, the weakest that will be registered. And if it's merely descriptive, if we can't show anything else that it does than describe, then we have to show that it has become distinctive to get it registered as on the principal register that gives you the presumption of exclusive rights. Now, the third category is suggestive. So for movers, Glide Movers might be a suggestive business name or brand. And you don't actually search for a mover that glides when you're talking about moving services. And so that takes a little bit more, it takes just a little bit of extra mental thought or creativity to make that connection between what they're offering and this term of glide. So that's stronger than the descriptive trademarks, but not as strong as the strongest category, which is fanciful or arbitrary. Fanciful means something that is made up. A fanciful term, Kodak, is not a term that's came from the dictionary or any language. They made up the term Kodak. And then arbitrary are terms that don't have anything to do with the services you're offering. So fruit doesn't really have anything to do with computers. So Apple Computers, which is a fruit, would be an arbitrary name when applied to computer services. On our moving theme we've been doing, bananas moving and storage would be an arbitrary. The bananas part would be arbitrary and would be a strong trademark if it's exclusive and that's registered and used that way. The other thing that is fanciful are drawings, and logos can be fanciful. For example, if you have an image of a fox or some other animal for your brand, that's going to be fanciful. Now, the challenge here for marketing companies is that when you have an arbitrary or a fanciful term, it takes a lot of extra work to get people to see it and remember that that's a moving company, because bananas have nothing to do with moving. So people might not make that association until they've been exposed to it more times than something that would be highly descriptive, or even maybe suggestive. But so that's this dichotomy, this inverse relationship between the strength of a trademark and the initial advertising appeal of a trademark. So the strong trademark often has a low initial advertising appeal, and a trademark with a high initial advertising appeal is often a weaker trademark. So when you're choosing a trademark, it's important to consider, how do you expect to be enforcing this? Is this something that you are actually going to put enforcement effort into? And if you are, you want that enforcement effort to go as far as you can. So on moving companies, I've seen a brand called Two Men in a Truck. And when I was just researching brands, I was curious if other people are offering similar but different brands. And when I looked, I could find people offering Three Men in a Truck. And I don't know if Two Men in a Truck, which is a company that's done really well at marketing, and I don't know if they would be successful at stopping someone with Three Men in a Truck, because Two Men in a Truck can be considered a descriptive term. And so when you have something that's a different descriptive term but close, it's not as clear on whether consumers are going to be confused. So that's all the time we have for this episode. I'm Wayne Carroll, and this is Leveraging Inspiration.